The Hawaii law at issue here violates the constitutional right to keep and bear arms. Therefore, the judgment of the Court of Appeals for the Ninth Circuit, I call it circus, is reversed, and the case is remanded for further proceedings consistent with this opinion. And my favorite 4 words in the language, particularly as of late, it is so ordered. That's a beautiful thing. And you know what else is a beautiful thing? This boneheaded tweet from Gavin Newsom. Gun laws keep people safe. This ruling by Trump's Supreme Court will only endanger people. Actually, he would say it more like, gun laws keep people safe. This ruling by Trump's Supreme Court will only endanger people. If Justice Alito really thinks people need guns to go to the grocery store for self-defense, this country is truly broken. I can't even read the replies, ladies and gentlemen. I can read mine. Shut up, loser. What exactly happened here today, ladies and gentlemen? This is the Wolford v. Lopez case. Now, I wasn't going to bet on this coming out today because I had heard from an insider in Washington that the court might be extending the term a week, which means this decision release could have been a week, although the expected date for the release was, in fact, today, and at a little bit about 5 after 10, it hit. Let's break it down. For years, Hawaii made it virtually impossible to obtain a carry permit. For years. Then came Bruen in 2022. The court said Americans have a constitutional right to carry a handgun outside of the home for self-defense. So what did Hawaii do? Did they embrace the Constitution? Did they embrace Bruen and the Supreme Court? Did they respect the court? No, they did not. Did they comply with the court? Not exactly, no. Instead, Justice Alito wrote this opinion, and we're going to take a deep dive into this right now, ladies and gentlemen, along with a couple of the dissents and Ketanji Brown's statement that cements her in history as the single biggest embarrassment historically to ever sit on this court. We'll go there shortly. But Hawaii didn't pay attention to it. Instead, according to Justice Alito in the opinion, it was a 6-3 decision, by the way. The usual suspects, Kagan Sotomayor and Ketanji, dissenting. Again, we'll go there shortly. But Hawaii just replaced one system with another. They flipped the script on state law that achieved almost the same result, except it failed, ladies and gentlemen. And that sentence tells you where this opinion is headed, because the court believed Hawaii wasn't trying to comply with Bruen. The court believed Hawaii was trying to work around it. And that's evident from Justice Alito's opinion. I would highly recommend you read this. If you do not read these opinions, well, you're missing out. Great stuff. Because there's a huge distinction here. Let's talk first about what Hawaii actually did. They referred to this, Greg, as you know, the vampire rule. Let's talk about that. Because it wasn't a ban on getting a permit, even though you have to jump through hoops that are ridiculous in the state of Hawaii. If you satisfied the extensive permitting licensing requirements, you could obtain one. But once you had your permit, you couldn't actually go anywhere with your firearm. Literally couldn't really go anywhere. If you did, you had to know specifically what the law was in any given quadrant of a community you happen to be in, from neighborhood to neighborhood, from shopping center to shopping center, from gas station to restaurant. Didn't work. And that was all by design, ladies and gentlemen. Imagine spending months obtaining your concealed carry license, get the background check, the training, all the nonsense, and you can't carry your gun anywhere. The state says, congratulations, you have a permit to carry, but here's a list of thousands of places that you can't carry, rendering your right to carry moot. So that meant you couldn't go into a restaurant, you couldn't go into a convenience store, a grocery store, a gas station, a coffee shop, a hardware store, a barber shop. You could go into none of these places, practically anywhere you would go during the day. Why? Because Hawaii, when they flipped the script, made so that you had to first obtain the express permission of the property owner. The presumption by the state was you can't carry on private property open to the public unless they say so. That was the script that was flipped that led to this case. Not implied permission, not assumed permission, but express permission. And that's what makes the case so fascinating. Because Justice Alito says Hawaii didn't merely regulate carrying, it completely reversed centuries of American common law. So think about this in terms like this. Let's say you're hungry. You're driving. You pull into your favorite restaurant. Do you knock on the door and say, excuse me, may I come inside? I have a gun. No, you don't. Why? Because when a business opens itself to the public, the law assumes you're invited. That's how America has always worked, because it's open to the public. Stores don't put signs on the front saying, customers welcome, do they? No, they don't have to. The invitation is implied simply because they're open for business, and Alito spent several pages explaining in this incredible opinion, a second one in 2 weeks, one from Gorsuch and one from him, but he explained exactly the historical principle. For centuries, businesses open to the public have extended what's called an implied license to enter. Unless the owner specifically tells you to leave, you are presumed welcome inside. That's ordinary American life. That's how we do our life every single day, at least, you know, on the other side of the blue wall. But Hawaii flipped it upside down and said, you may enter unless you're told no. The state said if you're legally carrying a firearm, you may not enter unless somebody first tells you yes. That's a completely different legal framework. And according to the Supreme Court, that matters a lot because it's a done deal. You heard me read. It is so ordered. It is unconstitutional and a violation of your Second Amendment rights. So, you know, I'm not going to go into all the places. I've got them written down, but I think you get the idea. He pointed out, Alito did, the practical problem here. Owners who don't object to licensed carry may still hesitate to advertise it publicly. They didn't want to put a sign there because they feared alienating other customers or leaving permit holders with no practical way to know where they may lawfully enter if they don't have signs. And that's exactly why the court said this law substantially burdens the exercise of Second Amendment rights. Not because property owners lose their rights. Keep that in mind. Property owners, this is going to play big in the dissents. Property owners don't lose their right. Property owners remain perfectly free to prohibit firearms in Hawaii if that's what they want to do. If they choose to do that, they can still do that. The problem is that Hawaii changed the default rule itself. Instead of liberty being presumed, prohibition became the starting point. And that's exactly what the Supreme Court was 100,000% unwilling to accept. One of the things Alito does is in this decision is he reminds every single lower court and every state legislature out there exactly what Bruen actually held. He walks through the modern Second Amendment trilogy, and he starts first with Heller in 08. And Heller, of course, in 08 is the case establishing something very fundamental. That is that the Second Amendment protects an individual right. It didn't establish that. It ruled in its favor because that's what it meant. That's what the Second Amendment means. Not merely a collective militia right the way the left wants you to believe, but the right to keep and bear arms for self-defense. It identified self-defense in Heller as the Second Amendment's, and I quote, central concern in that case. If you've not read it, I highly recommend you do. Then, the second part of the trilogy, here comes McDonald in 2010. What did McDonald do? That decision held that the Second Amendment applies against the states through the 14th Amendment and the Due Process Clause, meaning states don't get to invent their own version of the Bill of Rights. In this case, Second Amendment, as it applied in McDonald. That was 2010. Then, to go complete the trilogy, 2022, here comes Bruen, and Alito just had a field day. The Bruen case rejected the idea that judges should weigh away constitutional rights through balancing tests. Instead, the court adopted the history and tradition framework we've been talking about incessantly since Bruen 4 years ago. If the conduct falls within the Second Amendment's plain text, it is absolutely presumed to fall under the Second Amendment and be lawful. The government must justify its restriction by pointing to relevant historical analogs. Remember that, because when I get ready to tell you what that moron Ketanji Jackson did, I hope you're sitting down. I'll give you plenty of ample warning before I get to that point. Justice Alito doesn't reinvent that framework here, ladies and gentlemen. He reinforces it. When we come back, again, we continue our deep dive into what has just got to have the left and the anti-gunners just going absolutely bonkers, because they have been slapped upside the head yet again in 2 weeks with another landmark ruling. We'll be right back and break it all down. Remember what we just said about Bruen. All right? Justice Alito did what? He reaffirmed. He didn't reinvent anything. He reaffirmed what Bruen already said. He reinforced it. Okay? Very important. And here's where this gets really, really interesting, because there's a really quotable line here. There's a lot of quotable lines from Alito in this opinion, but my favorite's coming up. Here's where it starts to get kind of fascinating. Because of what Hawaii argued, Greg, you remember this, they were arguing the spirit of Aloha, right? Yet Hawaii has historically regulated firearms for its entire existence, and Hawaiians don't like guns. Well, too bad for Hawaii. Hawaii's part of the United States of America. It's pretty much that simple, guys. Deal with it. Hawaii argued that its own customs and traditions justified its law. They had to know that was a stretch. They absolutely had to, but they also know they're in the Ninth Circus, which found that, yeah, that's true, that you can do that, until the Supreme Court got involved. So the state essentially suggested that Hawaii's unique history supported a different approach to firearms than anywhere else in the United States. And Justice Alito got pretty simple, pretty direct, and I love this because it's memorable. We'll probably be repeating this over time for years to come. He wrote in the opinion, and I quote, "The Second Amendment has the same meaning everywhere in the United States. The Constitution cannot yield to the spirit of Aloha any more than it can yield to the spirit of the Big Apple or the Windy City." Clearly a smack in the face to both of those two very blue gun-hating locations. But if you think about what he's saying, it makes perfect sense, right? To anybody with a clear head, that rights don't expand when you move to Texas. They don't shrink when you move to Hawaii. They don't change because a legislature dislikes them. Keep that in mind. That's number two to keep in mind when I get to Ketanji Brown's boneheaded statements. All of this matters. The Fourth Amendment doesn't change when you cross the Nevada line, okay? And neither does the Second Amendment. So that's basically a reaffirmation of the power of McDonald incorporating the Second Amendment to the states through due process in 2010. That's how all this ties together. So the Bill of Rights, as we all know, because we're clear-thinking people and get it, we're not a bunch of emotional goofball liberals that just can't figure it out because we can't think, because all we can do is feel that we don't like guns, just like that idiot comment from that clown out in California, Gavin Newsom. But the Bill of Rights establishes national constitutional guarantees, all of us, not regional preferences, because Hawaii doesn't like it. Too bad. Secede. Good luck with that. The court emphasized in this case, in the court being Alito, that local attitudes cannot shrink nor can they inflate the meaning of constitutional rights incorporated against the states through the 14th Amendment. Again, the strength and power of the McDonald decision. All of these cases matter down the road as all of this stuff gets litigated. It comes to fruition. So then Alito turned back to history. Bruen, where conduct that falls within the scope of the Second Amendment's text is presumed to be lawful, the burden then shifts to the government, not the citizen, but the government. Hawaii had to prove its history supported its law because of Bruen and the precedent that Ketanji Brown acknowledged just a week and a half ago in the Hamani decision. So what historical evidence did it offer? According to Alito, not much. Because they looked at a couple poaching era laws where you couldn't hunt in the United States on someone's private property. And there were laws, local laws that prohibited people from entering private property to hunt deer or other game without permission. So what does poaching have to do with carrying a defensive handgun to a grocery store? Nothing. And the court realized that. The court explained in the case, and I quote, that those old laws were aimed at protecting landowners and wildlife from unauthorized hunting, not preventing ordinary citizens from carrying firearms for self-defense while conducting everyday business. The historical purpose and practical operation simply weren't comparable. And Alito said the gap between those laws and Hawaii's modern restriction, claiming this ridiculous spirit of Aloha, was just too much, Wrong history, wrong purpose, wrong tradition, wrong analogy, according to him. And then the court also examined another historical statute involved here because it was brought up by Hawaii when it was argued. And if you watch the oral arguments, you saw this. But it was an 1865 Louisiana law. And this is where it becomes really significant because the black codes are involved here. And Barrett, in a concurrence, spent a significant amount of time on this. I won't spend a lot of time on Barrett. I'll just simply say this right now. Her concurrence basically flat out just agreed with, if you will, the majority opinion written by Alito. Okay, so follow me on that. That's what it was. It was a lengthy, I agree with this decision, and she basically reiterated every part of it. And that, to me, was a signal. That was Barrett signaling future litigants and future cases upcoming, her strength and reinforcement of both Bruen, McDonald, and, of course, Heller, and her strengthening position, or her strengthened or strength on, however you want to frame that, Second Amendment. That's what that was. So you can read a lot into that. That's for another show. We'll probably cover some of that on Sunday. Now, Alito reminded readers of in the decision that those laws that were enacted during Reconstruction, what they pointed to in 1865 Louisiana during Reconstruction, were meant to disarm newly freed black citizens and leave them vulnerable to violence. We all know the black codes. It took 145 years for Georgia to wipe it out in the frame of getting rid of their public gathering laws, which, by the way, Hawaii still has, okay? They haven't gotten rid of any of that. Maybe that's the spirit of Aloha, too, is racism and black codes, disarming blacks. Maybe that's part of Hawaii's spirit of Aloha. I don't know. Have to ask them, right? But again, he pointed to McDonald, where the court discussed at length how the right to keep and bear arms was critically important for freedmen after the Civil War. And it was. The very Congress that drafted and secured ratification of the 14th Amendment understood that disarmament had been used as a tool of oppression during Reconstruction. And Alito was brilliant when he alluded to the fact that it was Republicans that fixed all of these racial problems. I do not think that was by accident, ladies and gentlemen. That was a history lesson written into his decision. And it is, frankly, a really remarkable piece of not just constitutional history, but American history. The court wasn't merely saying Hawaii found weak evidence. It was saying Hawaii relied on evidence that cut against the very constitutional fabric and principles that the 14th Amendment itself was adopted to protect. So, sorry, nice try again. Fail, boom, right on the forehead. Constitution, smacked him right upside the head. So where does that leave us? Justice Alito concludes, obviously, that Hawaii's law simply doesn't regulate the right recognized in Bruen. It substantially burdens it. And when we come back from the break, we continue the deep dive. We'll go into part 2, because Alito doubled down on Bruen. I'll explain, and we will eventually get to Ketanji Brown. Oh, good heavens, good heavens. Does DEI hire ring truer to the show page? So if you were listening to the first couple segments, you know the Supreme Court has once again told anti-gun states that the Second Amendment is not a second-class right. Again. This is the 5th case we've won at SCOTUS, ladies and gentlemen. You think they're feeling the heat there, the other side? I got to tell you, because this win is not just another Second Amendment win. This is a roadmap, folks. It's an absolute roadmap, and you'll see it unfold. Why? And I think you figured that out the other day, because yesterday we talked about the Commerce Clause and where Thomas went with this and why he did this. Again, yet again, another roadmap. It tells every federal judge, this case in particular, exactly how to analyze these cases in a post-Bruen environment. And if you're a state legislature that's trying to reinvent a clever workaround like Hawaii did, no. Justice Alito just made your job a whole lot harder, and something that gets kind of overlooked a lot, because a lot of people think that Bruen created a new constitutional test. It did not. It didn't at all. Alito reminds us in this decision that Bruen simply applied the principles that were laid out by Scalia in Heller that were never applied. How does that happen? The left can read you Heller and claim that it's a gun control favorable ruling. They flip the script. They hijack the language. Why? Because they talk about interest balancing. What is interest balancing? We've heard the term passed around here on the show over the years. It's the idea that a judge can say to you, yeah, you have a right to keep and bear arms. However, we think public safety in this case is more important than that enumerated fundamental right. That's balancing interests. And Scalia completely rejected that in 2008 in the Heller decision. Alito just simply reinforced it here again. Yet again, building momentum on top of each individual case. Wait till we get an assault weapons ban case, folks. Oh, they're going to hate it. They're going to hate it. We're going to be rejoicing like crazy. Yeah, so all he did was reinforce Heller. And what Scalia, and I can never blame Scalia. I've always wanted to see him go outside the guideposts here, but he couldn't because of the narrowness of the case. So I understand that. But here we are all these years later. Now, let's take a look at a different step here. Let me go a different direction. Alito asks three straightforward questions here. First, are these people among the people protected by the Second Amendment? Nobody disputed that in Wolford, meaning people in Hawaii that want to get a permit to carry a gun. And they, by the way, did not say anything about the permits and all the nonsense they have to go through, okay? That's presumed in there. They were ordinary law-abiding Hawaiian citizens. Second, were they carrying arms? Yeah. Again, nobody disputed that. Handguns have already been recognized by Heller as arms protected by the Constitution. That's going to pop in an assault weapons ban case coming up. Third, were they trying to bear those arms in Hawaii? Absolutely. No dispute there at all. They wanted to carry handguns outside the home for lawful self-defense, which Heller tells us we can do. And McDonald, and now Bruen, particularly Bruen on that, because Heller was more, I digress, Heller was inside the home and keeping a gun in D.C., nuance. But all three questions had the same answer here, ladies and gentlemen. Yes, yes, and yes. And Alito figured that out pretty quick. That means the plain text of the Second Amendment covers their context. At that point, Hawaii had a constitutional problem, and they knew it. Because once you've reached that conclusion, according to Bruen, the law is automatically presumed to be unconstitutional, and the government has to prove and justify it historically, not through interest balancing. Keep that third one in mind for Ketanji Brown's boneheaded statements when we come up in the fourth segment. You can't do it politically. You can't balance it emotionally. You can't balance it statistically, okay? Historically. And there's no balance at all. And that's exactly what Justice Alito says. Hawaii's argument, he says Hawaii's argument just began to collapse on itself. It imploded. The state didn't dispute that these citizens had carry permits. It didn't argue that they were dangerous. It didn't even try. It didn't argue that they were prohibited. Instead, it argued that history supported reaffirming their permission before entering private businesses because of the spirit of Aloha and those two very weak, the hunting on private property in the 1865 Reconstruction laws, which were found to be the origin, really, if you will, of the black codes. He examined, Alito did, every single historical example that Hawaii offered. And by one, he dissected them and blew them away and explained in great detail how and why each one of them failed. Some were anti-poaching, he said, as we talked about. Others dealt with trespass. Still, some others were isolated laws enacted long after the founding in the mid-second century of the existence of this country. None of them imposed anything, not one thing resembling Hawaii's sweeping, what we call it, default position, because they flipped the script, on licensed carry in ordinary businesses that are open to the public. And that's a huge distinction. The court is saying here, and Alito said, history doesn't have to match exactly. It doesn't have to be perfect. It doesn't have to be a perfect analogy. In fact, Alito went as far as repeating in Bruen's point that the government doesn't need a historical twin, and that's what was stated in Bruen. Again, read the decision. But it does need a historical analog that's similar, that is relevantly close to both how it operates and why it existed. And Hawaii just came up way short on this, guys, and Alito picked them apart. The court concluded that the state's examples regulated fundamentally different conduct, if you will, for fundamentally different reasons. The how and why did not line up, according to Alito. And when the how and why don't line up, ladies and gentlemen, smacked down by the U.S. Constitution. That's what happens. So again, he's doubling down on Bruen. Bruen, again, for just a minute. When the Supreme Court decided Bruen in 2022, a lot of anti-gun politicians said that they would comply, right? But you know what they did behind the scenes? You know what they did, especially if you've been listening to this show. They began asking different questions. Not how do we comply? No. because they have a different end game in mind. It wasn't how do we comply, it was how do we get around this crap? What are we going to do to get around this? And the usual suspects, California, New York, Maryland, New Jersey, and of course Hawaii, a state we don't talk about that frequently, but they did the same thing. And they all adopted approaches that were relatively similar. Don't think they were talking. They were. Folks, they're Democrats. That's what they do. They talk amongst themselves. How can we infringe on these rights? Let's get together and make it happen. When it starts to look like a coincidence too often, it's generally not a coincidence, folks. Okay? So what they were trying to do was make people's carry permits, which they were forced to do, really irrelevant by changing their laws, flipping things upside down. It's not accidental. The language that they put in these bills is not accidental. Again, it's a roadmap to how they work, and very, very important. But when we come back, I want to go to, because I know Greg's going to tell me we're going to have to take a break. I want to say, too, what the court, what Alito didn't say in here. Because Ketanji Brown, they're all going after private property rights. And I'm going to go to Ketanji Brown's dissent because she is utterly so stupid. It's an embarrassment to see her sit on that court. It really, truly is. And when you hear it, it will blow your mind. But it won't blow your mind because you know Ketanji Brown is a flat-out moron. And we come back, I'll break that down for you, and we'll rag her just a little bit because she makes it so easy and so fun to do that we're going to have some fun at her expense, using her own words verbatim, direct from her dissent. And it will, I say it will shock you, might shock you hearing it if you haven't read it for the first time, but it won't shock you because of who it's coming from and the way they think or don't think. You see how it's tough to get in a liberal head? We'll be right back. Let me go back here because I have got to go back to one thing, a couple things. And I want to cover what Alito did not say in the Wolford decision today. The court did not say that private property owners lose control over their property. They didn't say that. In fact, it was far from it. If a restaurant owner wants to prohibit firearms, the restaurant owner can do so. They absolutely can. If a grocery store wants to post a no firearm sign, they can. That's still their decision. Nothing in Wolford changes that. The issue was not private property rights. The issue was the state of Hawaii making that decision for and on behalf of every private property owner in the state. And there's a huge distinction there. Alito recognizes that private property owners retain authority to admit or exclude armed patrons if they so choose. But the state can't force that to be the presumption out of the box. That's where that happens. Let's go over to what, now, remember I said, remember those three things. Also remember private property. That's the fourth thing that I mentioned to you. And you'll see it all tie together here because here's Jackson's dissent. For what it's worth, I think Bruen was wrongly decided. Well, let me go, you know what, because I've got a couple minutes, I'm going to go up to the top because it's important. Yet again, she reaffirms Bruen as precedent. This is the second time in 2 weeks that she's done that on a Second Amendment case. Interesting. How and why? History will judge that as more subsequent cases come down the pike. But today, she said, and she was joined by Sotomayor, by the way, in her dissent. Kagan wrote a separate dissent, albeit a very short one. Today, the court declares unconstitutional Hawaii's efforts to protect the rights of its residents. Hawaii's efforts to protect the rights of its residents. Are we interest balancing here? Take a listen and pay attention. Both those who wish to carry guns and those who prefer that guns are not carried on their private property without their express permission. To hear the majority tell it, Hawaii's law is a blatant attempt to end run our Second Amendment precedents. But the statute at issue does no such thing. That's the vampire rule that we just talked about. Instead, it fairly applies a first principle of property law, the right to exclude, and does no harm to the Second Amendment. The majority thinks otherwise. It reaches today's result by purporting to apply the test we established in New York State Rifle v. Bruen, in the test we established in New York State Rifle v. Bruen. She's affirming that again as precedent. But the majority gets both the Bruen test and its application wrong. Hawaii's law does not implicate the Second Amendment because there is no right to carry a gun onto private property without consent, as all agree, and the Constitution does not dictate the form of that required consent. except Alito just shredded that. She didn't hear it, apparently. And even if the Second Amendment were implicated here, which is an admission, by the way, Hawaii has proffered ample analogs demonstrating a history and tradition of states protecting their residents' property rights by requiring those wishing to carry guns onto private property to get express consent from the property owner before doing so. Now, here's where she gets into the meat. For what it is worth, I think Bruen was wrongly decided. She mentioned that, okay, in Hamani just days back. But if it's going to be our precedent, lady, it's not if it's going to be our precedent, it is precedent. Deal with it. The majority should at least endeavor to apply it faithfully. I respectfully dissent because the majority has failed to do so here. And its analysis and conclusion only further bind the hands. Listen to this carefully. And its analysis and conclusion, meaning the majority opinion, only further bind the hands of modern legislatures attempting to balance and protect their residents' interests. You cannot make this stuff up, ladies and gentlemen. We just discussed interest balancing. That's why I wanted to focus on that, because the stupidity from Ketanji is just off the charts. That's exactly what the Bill of Rights is intended to do, is to protect from modern legislatures attempting to balance and protect their residents' interests. You have to ask yourself this question. Does she even realize what she writes? I don't think she does. I don't think she writes all this. She's got clerks that do all this. And this is just evidence that her entire staff is a bunch of morons. She continues, with this decision, the court has now manipulated Bruen into a free-for-all that lets the judiciary thwart the will of legislatures by privileging access to firearms above all else. Firearms, not rights, firearms, a tool. Do you see how they think? They let you know from time to time. Today's decision makes one thing clear. The court's objective is protecting guns, not consistently preserving any principle of law. Then she goes into the stupidity that Alito just shredded. Since its time as a sovereign kingdom, Hawaii has never permitted the widespread carrying of firearms in its territory. And she goes on to talk about King Kamehameha and the spirit of Aloha and how Hawaii prohibited the possession of dangerous weapons. Translation of the Constitution and laws of the Hawaiian Islands established in the reign of Kamehameha in 1842. She points out that was reprinted in 1934 to try to bolster her case, which also, by the way, ladies and gentlemen, targeted, according to her, any possession of any knife, sword, cane, or any other dangerous weapon. Hawaii maintained this tradition of strictly regulating weapons both before and after it was annexed as a U.S. territory. Too bad. Because once it was annexed as a U.S. territory, the U.S. Constitution becomes Hawaii's law, the law of the land. Bye-bye, spirit of Aloha. And she goes on to point out that Hawaii began regulating guns in 1927. Everything they're doing in today's modern America, since they've become a state, is a violation of your constitutional rights. And Wolford just laid that absolutely bare. And to believe that she is so stupid to write the fact that she thinks that the reason it was wrong is because modern legislatures can no longer rule around. In other words, think everything we just talked about in the first two segments. Everything New York did, not to comply with Bruen, but to get around it. Everything Hawaii did to get around it, not to comply with it. Illinois, all the usual suspects. California, Jersey, Maryland. That's exactly why our Constitution was written the way it was written. It's exactly why the Bill of Rights was written the way it was written, so that these people can't do those things. The limit is on the government, and she wants the government to have carte blanche locally. We're going to get up and do it again tomorrow, folks. Armed American Radio's Daily Defense. Stay safe. I'll see you on the radio. All right, guys. I'm going to jump in here for a second. Had a lot to cover today. Wanted to get to all of it. Let's see. We got a lot of comments in there. Susie says, happy pre-Friday to the AAR family. Yeah, it's now Friday as far as we're concerned. Right, Greg? Isn't that true? No, Greg doesn't.
Yeah.
It is. I've been convincing Greg that Friday really starts on Thursday. Okay? That's try to give him that extra day in his mind.
Not convincing me. I'm just playing along with it.
Let's see. Texas Huntsman. Got to love you, Texas Huntsman. Stick that up your Aloha tyrants. Let's see. If Hawaii's going to base all their opinions based off their cultural traditions, this Texan would like a word about federal taxation, among other things. There you go. Yeah, so you guys get it. FW Rose 6272 says, I just like the hula girls. Who doesn't, man? You know, we all do. All right, guys. Great program today. Great news. Celebrate another huge victory. They have now been beaten back at the Supreme Court 5 times. Count them, 5 times. And they're going to get whacked again when a gun ban case is taken. It is going to be the nail in the coffin, guys. Enjoy your day. Stay safe. Thanks for being here. Please subscribe on YouTube. Get the notifications. Ring the little bell. Like, comment. Please do so. We appreciate it very much. It helps the channel grow, and we are growing huge, by the way. And we need your help to do it, and it's because of you that we are. Thank you all for being here. Thanks for watching us. Join us and subscribe over at YouTube. We would appreciate it very much. Like, share, comment on the videos. I'll see you on the radio tomorrow, guys.